Some judges are extremely worried that mediation takes interesting cases away. It isn't much fun being a judge in the United States for a lot of judges. The really interesting things, come in the door and go out to a mediator, and guess what? They come back settled. That case may have settled anyway, but it certainly doesn't add to your job satisfaction as a judge. They feel like the good cases leave, and then they're stuck with the bad cases that can't settle and that are no fun to try, and that's just not a very fun job. Clearly, cases settle without ADR. I already said that. Many of the judges said, the case is settled, but we don't know if it's ADR that is causing that case to settle. It would settle anyway. I think that this is a huge policy issue when we start thinking about resources that go into the development of alternative dispute resolution, and yet we don't really have an answer to what's happening in the settlement process. And if the cases would settle anyway, why do we need ADR? We need to be really clear on what the value added to ADR is. I think we can be, but I think sometimes we don't take the time to be clear about those policy issues. I'm talking too fast. I'm sorry. In the United States, I'm known at conferences for covering twice as much information as anyone else because I talk so fast. So I will slow down and cut out a slide or two. I'm sorry for the translation. The last thing that judges had to say, talk slower, is that clearly some cases do need a day in court, and they should have a day in court if that's the case. We need jury trials for some kinds of cases. We need jury trials for some precedent-setting legal issues kinds of cases. We need judges and civil procedure to protect rights when there are great power imbalances. Not all cases should settle. These were comments, qualitative comments that the judges made on the survey instrument. Implementation issues to distinguish between sort of the limitations from their data is my word. There are things we could do about these issues. The fact that parties are sometimes denied adjudication when they want it. Perhaps mandatory programs, though I was initially quite in favor of them, have some really serious policy and justice issues. Perhaps once ADR has been introduced in a United States court system at least, we need to back up a little bit from requiring, mandating, pushing parties to use ADR. One of my questions actually asked judges about forcing non-represented parties to go to ADR. It was incredible, the percentage of time that judges force pro se, non-represented parties to use mediation. I think this is a policy question that we will have to look at when we think about justice issues. No rulings on dispositive motions. Dispositive motions, again, I think Jeff Singer referred to them as one of the ways that cases get settled before trial in the United States. Many people will ask for a judge to rule as a matter of law early on that the case doesn't need to go to trial, and many judges will not do that. They will say, no, we'll wait and let this case go through mediation. There's some definite problems with what is the judge's role, again, as one of the speakers said in the very last session, and if it's the judge's role is to rule on those sorts of things, to make those legal decisions, and I think we need to think more carefully about when and how we are basically forcing parties to not get adjudication when that's what they want, when that's what they ask for, when that's when they're entitled to. Parties excluded simply means that in a lot of cases the parties may not be at mediation. Professor Sho referred to that. Okay, really quickly, except I won't just cover it all because I can't go really quickly. The attorney's data, the study that I did asking for attorneys' information, the attorneys are choosing mediation for very good reasons of reducing their expenses, getting earlier settlements, making settlement more likely, and they are seeking mediators who would be most helpful in that arena of reasons, that have substantive experience, that are litigators, that know how to value a case so that they can be very helpful to the case. And they do perceive mediation as less adversarial. However, The attorneys also are people, this is a quote from the study, case circumstances require full discovery before a case is ready for mediation. I just don't think that's true. But we use a phrase of the lawyer's philosophical map. Educating the lawyers to understand that they don't have to do full discovery, that can also affect the very positive reasons that they're going to mediation, is a very hard task. That's why many law schools like my own are working hard to get the alternative dispute resolution content into the everyday life of the law school student. The lawyers don't think that all cases are appropriate for mediation. I agree with them. The lawyers also recognize that the number of settlements itself is not increasing, and so that raises some policy issues. Implementation issues. Let me just refer to a couple. I don't know how to do this. The technology. I'm pointing on my screen, but you all can't see that. Mediation's potential to produce creative solutions and preserve relationships is not widely acknowledged as relevant. Earlier speakers today brought out that is part of the great potential of mediation, and it is a great potential of mediation. But when lawyers are asked why they're using mediation, that is not their primary reason for going. And in fact, the number of lawyers that recognize the importance of relationships and creative solutions is unbelievably low. There is so much we need to know, but in the United States, a lot of the research, the client voice is largely missing. There was early client data, but the data, not counting the federal government data that Jeff Singer reported on, we're mostly talking about things like what the lawyers and the judges had to say. This value-added certainty, as I mentioned, is missing. Even the efficiency data is actually missing in terms of real proof of the efficiency. And then I think there's an important issue about whether there is a point at which there would be too few trials. Mediation takes place, in theory, under the shadow of the law. That the negotiation that is happening bears some resemblance to what would happen if parties went to trial. And if there are too few trials, is that a danger? Could it present any problems in the future? Is ADR working as we intended? An enormous problem there is simply that for many programs, setting clear goals and being sure of what we did intend, and then looking back and evaluating on what we did or did not intend, is sadly lacking. The court systems in the United States are not very good at collecting data or putting data into their just regular data collection systems. So being able to make really concrete conclusions is a very, very difficult task. Thank you for being so patient.